We read often about defendants in court who say it was self-defense in cases involving drug deals gone bad, brawls in which both combatants were willing participants, and I even read about a teen who shot a teacher and several classmates at school who said he acted in self-defense. Clearly, sometimes the decisions about how self-defense trials are conducted don't involve good, decent citizens like network members, so the poor judge has to decide whether to let the lawyers lay it all out for a jury, refuse to give a self-defense instruction to the jury after all the evidence is presented, or as I understand it, the judge can refuse to admit evidence and testimony or even prohibit any mention of self-defense. We turn to Network President Marty Hayes to explore why a court might disallow a self-defense argument. Tell us about your background, Marty, and then I wonder if you could identify common factors you and others who work in the criminal justice system see time and time again when defendants would like to but are not allowed to argue self-defense.
I've been a cop for the first part of my life, from the late 70s to the early 90s. And of course, with that police officer status, I interacted with many people that were involved in using force. Also had the education that law enforcement officers get. In addition to that, I have worked as an expert witness in court cases since the mid-90s on up to present. I looked at my CV the other day, and I've been involved in more than 20 self-defense legal cases. They didn't all go to court, but many of them did. A lot of times the charges were dropped, either through a plea bargain or just simply the prosecutor realized that they don't have a winning case here. So, of course, after or during that time, we started the Armed Citizens Legal Defense Network, and that was after I went ahead and spent 4 years completing a part-time law school program. And so that's my background in this discipline. And of course, for the last 15 years, as president of the Armed Citizens Legal Defense Network.
Well, I think today it would be very useful for us to identify and discuss common factors that you and others who work in the criminal justice system see time and time again when defendants would like to but are not allowed to argue self-defense.
The court has a right, when I say the court, I'm talking about the judge. The judge has a right to disallow a self-defense discussion in court and disallow a self-defense jury instruction. That happens when two things. First of all, the defendant committed some type of crime or was in a place he wasn't supposed to be, or otherwise doesn't have the right to argue self-defense at trial. This will go state by state based upon their statutory and case law, and so I'm not going to go much further there. The second time is when the defendant committed an act that would lead a reasonable person to believe that they started the altercation. It doesn't have to be a physical fight. It can be verbal, physical gestures, that kind of thing. So those are the two primary times when a person won't even get the chance to argue self-defense. I'm going to say one more thing. A third time is when there is no evidence presented at trial that this was a case of self-defense. And what typically happens is that a defendant is represented by an experienced or maybe inexperienced criminal defense attorney who believes that the defendant should not take the stand and should not discuss what was happening to him that caused him to believe his life or the life of someone else was in danger of death or serious bodily injury. Consequently, if he doesn't take the stand, there's no evidence to believe that his life was in danger, or if there's no evidence to believe his life was in danger, then the judge will say, you have not given us any credible evidence that self-defense was warranted, and thus I'm not going to allow you to argue self-defense. This is why one of the things that we expect to hear from our members who are involved in acts of self-defense is, I want to know if they're willing to take the stand. Because if they're not willing to take the stand, then there's a pretty good chance they're going to be convicted. And while we would still represent them under those circumstances, I got to break the news to them. You're probably not going to have a very successful case of self-defense.
Going back to that overview that you gave us before we began talking about testifying at trial, there was a lot of just kind of subheadings given that I'd really like to delve into more in depth. And one of them you talked about committing a crime, and we didn't really discuss what those might entail. And then there's the question of provoking the incident, which I believe you also mentioned. And I wonder if that's related to overlap to being a willing participant. The reason that comes to my mind is there was an infamous quote from the Rittenhouse prosecutor's closing statements where he said, "You cannot claim self-defense against danger that you create." Well, obviously that didn't work out too well for him. But I suppose he would have preferred the jury not receive a self-defense instruction, which, again, didn't work out for him. However, I'm wondering if you can talk to us a little bit about that willing participant, and also about whether you provoked the incident. Are those two the same things? How do they differ?
Well, I'm thinking of the standard two guys get into a fist fight.
Okay.
And they're both willing participants. And as long as they're beating each other up with reasonably equal force, they're not going to be able to claim self-defense. In fact, they're probably not going to be able to claim self-defense anyway if it escalates, because they're a willing participant. But at one point, if the fight does escalate, let's say two guys are duking it out and one of them grabs his knife and says, "You sucker, I'm going to stab you." The other guy grabs his gun and says, "No, you're not." He's not going to be able to argue self-defense, likely because he was involved in that incident to begin with.
Okay.
Another form is if you are committing a crime and then have to resort to physical self-defense. That would be if, say, you're committing a bank robbery. You're sitting there at the teller's window waving your gun around, and the bank security guard steps out of the restroom, zipping up his fly, and sees this and says, "Holy shit," and he pulls out his gun, and there's a gunfight. Well, the bank robber isn't going to be able to claim, "I only shot in self-defense, I wasn't going to shoot otherwise." And then the third one is, if you were the initial aggressor, if you started the fight. We see a lot of cases where you're driving down the road, fat, dumb, and happy, and you inadvertently cut somebody off, and the guy has a huge problem with you cutting him off, and he comes up behind you or beside you and starts yelling at you and cussing and flipping you off. While you didn't start that altercation, he did. And so if you pull over and he pulls over and he starts wanting to claim self-defense because you pulled out a gun and says, "Dude, just back away," then it was the first driver who started the road rage incident.
Those are so difficult because people say many times, and rightly, well, mistakes happen. I know I pulled out in front of people as, "Where the heck did that car come from?" And, thank goodness.
Was that right before or after it smashed into you?
Yeah, right. But people understand that there's that we're human and we make mistakes, and so then what happens if that escalates? Who indeed started it? The guy who made the initial driving mistake, or the guy who reacted violently? And those chains of events get real hard to suss out. And that, I think that makes the initial aggressor question mysterious to some people.
If the people viewing this are not getting a clear picture in their mind, that's because it's not a clear subject.
Yeah.
what I would recommend you do is get on Google Scholar, go to your own state's case law, type in self-defense or initial aggressor, different search parameters, and start reading those cases. Those cases are typically reported when a case results in lack of a self-defense instruction, and the defendant who ends up being convicted appeals, and the appellate court says, no, we think that the trial court should have given them a self-defense instruction. And so we're going to send it back to the trial court for a do-over. They lay out the areas of the incident and then explain why the person should have got a self-defense instruction. One of the foremost examples in Washington State is the case State v. Janes. In State v. Janes, the defendant, Janes, was an abused child. And he grew up being abused, and at some point in his, I believe, late teens, he killed his abuser stepfather. And it wasn't from the act of abuse. It was because he feared in the fairly immediate future that it was going to happen again. And so he grabbed a shotgun, went in the bedroom, and killed his stepfather. The judge failed to give a self-defense instruction and did not allow him to talk to the court about the abuse that he suffered. The appellate court said, no, the jury has a right to know what the defendant knew and know what the defendant saw at the time. And so they basically said that you go back, try this over, letting the defendant explain the type of abuse that he suffered and why he felt that he was going to be abused again and why he took that matter in his own hands.
And I think there's been a lot of parallels nationwide in domestic abuse cases, burning bed type of cases. And that's tough because you don't have that immediate right now and here fear. And so it raises another term that comes up, and that's unreasonable fear. I think sometimes we see that when shootings happen in parking lots or people thought something was going to happen. What is the definition there that you weren't reasonable to believe that something bad was going to happen to you, so you don't get to argue self-defense?
Well, it's not that you don't get to argue self-defense.
Okay.
It's just that the self-defense argument isn't going to work.
Okay.
Because, the jury is going to hear what you knew at the time, and they're going to be thinking, was it reasonable for him to use a gun and blow off the head of the perpetrator? And if they say, no, that really wasn't reasonable, he should have just walked away, and while he had a right to stay there, it was stupid that he did. It's going to be the jury that decides whether or not your actions were reasonable or you had a reasonable belief that you needed to take action. And that's going to be case specific. Every case is different.
Well, and I think that we're trying to learn principles that govern our actions so that we don't get into those situations, so we're not the defendant. But something you mentioned a minute ago kind of leads into a failure to withdraw question, or the concurrent one, which I think happens in case law somewhat too, is the person escapes, but then they return for unknown reasons, and the jury says, oh my goodness, we wouldn't have done that. So in those situations, is it common for all of the evidence and all of the testimony to be allowed? And then what happens to that jury instruction? Maybe you should talk to us a little bit about jury instructions. The judge has got a lot of discretion there, doesn't the judge?
Well, with jury instructions, they're basically the rules that the jury has to go by to find either a guilty or not guilty verdict. Okay. And so those jury instructions are typically kind of weighted towards the defense, but not necessarily so. The judges don't like to be appealed, and they don't like to, to be overturned, and so they're going to give the defense kind of a fair shake at it. But there are also plenty of times when they don't believe it was self-defense, or they are so anti-gun that they simply have a political agenda, and they're going to let that overweigh their jurisprudence.
So you do, you get back to that imminence factor, you get back to that, is it immediate now? Can I withdraw from it? Why did I go back into the fight if I knew it was, and that all seems to me to be related to that, really even that initial aggressor. Did I start it? Did I keep it going? Or did I try to stop it?
There was argument in the Spencer Newcomer case, which we've written about, and actually, which is back on TV, the Oxygen Channel, with a discussion on the case, where Spencer had a chance to drive away. He was in his car driving away, and the deceased started yelling and screaming at him, and at one point, the deceased says, "I'm going to get your dogs, I'm going to kill your dogs," or something like that, and Spencer stopped and backed up and said, "Nope, this is going to stop right here." Well, if he had just driven away, then obviously nothing would have happened at the moment, but Spencer didn't know whether the guy was actually serious about getting his dogs and extending out to his girlfriend, who would have been protecting the dogs. And so he stopped and got out, and the prosecution says he didn't have to do that. Well, Spencer said he did, and the jury believed that that was reasonable for him to do that.
Well, and I think the fact that his girlfriend might have gotten involved in defending the animals must surely have weighed for a lot, because that's a human life issue at that point.
Sure.
Hard decisions to make. Term that I ran into in doing this study that I'm not sure is exactly related to this, but maybe you can get us clarified. What is imperfect self-defense, and is it a defense against a murder or manslaughter charge? How does that work?
Well, imperfect self-defense is basically where you screw up one of the factors we've already talked about.
Okay.
Yeah, it was self-defense, but you started the fight, and thus you didn't have the right to finish it. Okay. Or, yeah, I can see why you're shooting the bank guard was a case of self-defense, because he shot at you first, but you don't get to argue self-defense. That was imperfect self-defense. And do a Google search on imperfect defense.
Another term that comes up when we're talking about allowing arguments of self-defense, sometimes it's called excessive force. That tends to be used a little bit more commonly when there's police-involved incidents. However, what happens if the defensive force used exceeds that's used against the defendant?
Well, it's not usually a case where the defense won't be able to argue self-defense, but it's likely that the self-defense argument will not prevail with the jury. Perfect example is a case I had a couple years ago where two people were arguing in a pickup truck cab, big Ford F-350 crew cab, and the defendant stated that the driver, and they were co-workers, and they didn't really get along with each other. And the defendant said the driver reached over to take the defendant's gun out of his waistband.
Wow.
At which point the defendant countered that, a little bit of struggle, and pulled out his gun and shot. And I was brought in as a weapons retention expert to show how easily that could have happened. The problem is, though, and this is the reason why he's still sitting in one of the prisons in Washington State, is he shot the deceased 10 times. And so one time might have been very defendable, but 10 times, including a shot to the brain from the top, basically the guy was here and he got hit here and he fell over, and the defendant kept shooting, including the last couple shots in the top of the head and in the neck. And so that was the case where excessive force he didn't have to shoot that many times. And unfortunately, we're seeing it more and more out there in the real world of reporting on self-defense cases, because the vast majority of people are using high-capacity firearms now, which aren't necessarily powerful enough to stop somebody with 1 or 2 shots. And so they end up having to shoot them, or at least they perceive they're having to shoot them, more than a couple times.
Well, and there's that immediate effect. I mean, the pistol caliber probably isn't going to strike them down. The human organism can keep up and keep going. And it almost seems related to another element that we run into, and that's the threat is no longer imminent. Has it broken off? And some of the worst cases is where people chase people or trying to run away from them. Well, that's pretty extreme. But what you just explained could come under that same heading. Was the deceased still a threat? Well,
yeah. Another case I had was where this lady was assaulted in her bedroom by her boyfriend, and she got to the gun and used it and continued to use it as she chased him outside the house. And she shot half a dozen or a dozen times, and with 1 or 2 shots hitting him as he's going down the steps. And that was excessive force. When he turned around to leave, that's where she should have stopped shooting.
Right. Right. One of the things that you brought up early on that we ought to circle back around to, because I think it is the nuts and bolts of this discussion, and that is the individual who used the force explaining to the jury and the judge why that was so necessary. So it seems like there's a lot of reasons that attorneys give for not wanting to put their defendant on the stand, and sometimes they seem to be pretty straightforward. I remember the late Jim Fleming talking to him about that, and he, without giving specifics, talked about clients who, I don't know that you'd say they were mentally impaired, but they were pretty scattered, that he just felt like they would come across as maybe even mentally incompetent on the stand, and he said he just thought that it would be cruel to even expose them to that. So I mean, I guess I mentioned that because I think that we can't just paint a broad brush and say criminal defense attorneys are wrong when they say don't put the defendant on the stand. But is there a kind of a risk-benefit analysis about a defendant testifying?
Well, I'm reminded of the Kayla Giles case, where she had a cognizable, perhaps reasonable right to shoot her ex-husband, but the jury never heard what was going through her mind at the time she pulled the trigger. Of course, the defendant always has a right to testify, but defense attorneys can be pretty persuasive. So Kayla chose not to testify, and the jury never heard about him having hit her before. They never heard about his martial arts background, and frankly, they didn't hear about the fact that he threatened her, and he grabbed and opened up the door before she decided she had to shoot, because she didn't get a chance to talk. All the defense could do was to try to stab holes in the prosecution case, and it didn't go enough. Having seen case after case after case after case where their criminal clients get up on the stand and just totally blow it and basically convict themselves, they say, don't ever take the stand. My law school professor in criminal law, her and I had an argument about this. And and this is all done over the internet, and so she's giving a discussion, a lecture on self-defense law, and she said about the witness not taking the stand, and I says, well, if you're a good attorney, you would be putting her on the stand or him on the stand. And she blew up, oh no, he never put the witness on the stand, blah, 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 blah. I said, okay, fine. You obviously have not done self-defense law cases. And she wasn't a very experienced criminal defense attorney anyway. But at that point, I knew that the law that the law school students are getting isn't necessarily cutting edge.
Did you pass?
I did pass that law.
Sorry.
It's kind of funny. The first year, I made the dean's list.
Education notwithstanding, there's also that experience factor that, and maybe I hark back to conversations with Jim, others, is if your criminal clients have erred so badly a dozen times, you probably would get a little bit gun shy and start to draw conclusions that there's a lot of risk. There's a lot of risk to letting your guy talk. And then we have the background, which was remarkable, and we all watched it with bated breath, and that would be when they prosecuted George Zimmerman in Florida, and he didn't take the stand.
No, he did
which
not.
He had such a story to tell of being attacked and didn't. Why was he not convicted?
Because he already told his story to the police on videotape. And the police prosecution played that for the jury.
Wow.
And so Zimmerman was basically able to testify in his own defense without having to subject himself to cross-examination. And that was, that was brilliant. I don't think he thought it out that way. He was just trying to help the police investigate this. And so he was just truthful and told them what was going on. And the good news is the witnesses in the area that heard and vaguely saw what was happening backed up his story. And so his story was very credible. Now, we don't recommend that you sit down with the detectives and give a 2-hour taped statement.
And in that one, I always found it remarkable that, and I don't know what happened behind the scenes, is something that would be very interesting to learn more about. If there was any attempts by the state to suppress showing those videos, and it kind of brings up the question, what limits can a judge allow? Presuming the prosecution would say, no, we really don't want the jury to see this. What limits can a judge put or allow to have imposed against, say again, that defendant's testimony, whether he or she's going to testify right there sitting in the court, or whether it's videography like you mentioned?
There's pretty much no time where a judge would not allow the defense to introduce prosecution tapes, either audible or videotape.
Yeah. Just remarkable.
Yeah, I don't see a time, and if they did, it would certainly very likely be overturned on appeal. And judges don't like to be overturned on appeal.
Well, and I think a lot of what we're seeing when we try to study up on this, and you're talking about using Google Scholar and looking at those, they're appellate records. That's where these arguments start to get spelled out, and those mistakes are made and identified and remanded back to the court. And I've always wondered, well, does the same judge have to hear the same material, or does it end up going to another judge who might see things differently?
Pretty much it's always remanded back to the first judge.
Yeah.
I'm sure there's cases where it wasn't, but that's what I've seen. It goes back to the trial court, which is the first judge.
Yeah. So I hear bad win percentages for appellate cases, that it's pretty hard to win on appeal, and I believe we had an attorney question about that last year, that it doesn't look likely, but it certainly is a good body of educational information for us. We should research our own state's material. Well, Marty, when we want to draw a bottom line or say what's the takeaway today about being allowed to argue self-defense in court, what do we need to keep in mind? What's paramount for us to know?
The courts pretty much allow you to argue self-defense if there's credible evidence to be able to present to the jury that this was a case of self-defense.
What's credible?
Credible means that a reasonable person would either believe it or likely believe it, or even possibly believe it.
Oh, really?
If there's no way that anyone would believe that nonsense, then it's not credible, and the judge will likely disallow it. But the judges also say, well, it's not going to do me any harm to allow it. It's probably going to convict him faster anyway, so they don't like to leave that open for appeal, and so they say, I'll allow it. Okay, sounds good.
Thanks, Marty.